is the presumption that you act in good faith to advance the best interests of the company. And so we had this thing where we were separating good faith from loyalty. It made no sense to me because what defines you as a loyal person, right, is did I act, if I'm your fiduciary, did I act in, if I'm your friend, did I act in good faith towards you? And so I think we've struggled. And the same thing with care. They try to like do this. It's usually if you're acting in good faith towards someone, actually you're acting loyally there, right? It's the definition of loyalty. The way you define loyalty is to act in good faith, to believe in the good faith belief that it's in someone's best interest. Usually, if you're doing that, you're going to try to exercise the reasonable level of care appropriate to the situation. So I think there's even an argument. One of my predecessors, Bill Allen, who's a professor at NYU since he's a judge, he and I always talk about it. That goes to that we're not even sure you need the duty of care. That when you properly look at the duty of loyalty. But certainly, I think this thing in between, you know, it's the only thing French about previous Delaware law apparently is that we embrace that confusion. Remember also, here's students, here's a reality that I think affects all judges. When you're uncertain, we call it highfalutin. They use fancy, obscure, complicated terms to describe their decision because they can't put in simple, clear terms why they're doing something. And so we had that problem. What? When they do this. Oh, no, I agree. I think the more you'll see this kind of fancy stuff, or like the more somebody says something is clear, if something's clear, you can just state the facts, right? When they put, we call it LY words, clearly, flatly, blah blah blah, or the, you know, and when you see judges do that, or we have this weird term in U.S. law, it is beyond peradventure. Who the hell? What have you ever gone on a peradventure? I mean, is that something involving cats? A peradventure? But when you see these things in law that no one says in real life, it's usually because the judge has come to a conclusion about how it should come out, but is actually not capable of explaining in a common sense way. And one of my things I would urge you as lawyers is the more you can be, we call it noun and verb, the more you can actually show rather than tell, right? When somebody reads your paragraph, they read your thing, they come to their own conclusion because your sentence is what you tell them about the situation. And it's the same for judicial writing. And I think, Gustavo, some of this is people gussy up stuff, come up with complicated terms, and then they get lost in it. They start believing it when they don't even remember that it was just BS to get through the moment.
But sometimes it's harder to write a good decision when you have a very bad case, no? And even the construction of good faith as a separate fiduciary duty in the Disney, I think, is because the case there was a hard one. So.
Well, it was a hard one politically because they made it hard. It really wasn't hard at all. The Disney, I don't know if you've heard about the Disney cases. The story was the one. Have you ever heard of Gwyneth Paltrow? Yeah. Well, this guy had Michael Ovitz was the kind of, you know, he was riding around Hollywood with Gwyneth Paltrow in the back of his car. He was the most powerful agent in Hollywood. He was the head of CAA. He had a very valuable business. Disney needed to bring in a deal maker. In order to encourage him to come, he had to give up his business. So they agreed to pay him a lot of money. He couldn't ride around with Gwyneth. He couldn't ride around. He gave up a major business that he controlled. It's not an inside promotion of a dullard. He gets in there, to be honest, there were insecure egos on the part of Michael Eisner and people, and he ends up leaving in 2 years. They never succeed. They were worried about his expense account. Like if you were going to take Beyonce, you know, out on the town to talk about a thing, like you had to worry what she could only get a hot dog at a Mickey Mouse kiosk. I mean, it wasn't going to work. And then, but people sued because it was so much amount of money, his severance, despite the fact that the severance didn't possibly cost. So the Delaware courts, to be honest, was a little political. It was worried the Court of Chancery dismisses it in the first instance. It went up to our Supreme Court and they sent it down. And I think we faced, to be honest, be honest about it, we live in a political world, right? You live in a democracy. That's something to hold on to. Don't let anybody, you fought for it, don't let anybody take it from you. But courts are within a societal context. And I think what Gustavo was saying is, icky situations. I mean, they're also, the smaller the company, by the way, the more complex the problems. No, I mean, they don't hire Julian or Chico's firm when you get a small company. They take shortcuts. Then they come to court with a mess. Here's one of the advantages, though, of the case-by-case system. We've been able to put Disney in its place. It costs some money to get done, but it eventually got dismissed with no liability. Should it have been quicker? Sure. Did it cause catastrophic societal harm to business? No. I also urge judges, write narrowly. The more cluster, whatever, that's a term in the US. I won't use the term I won't use the Jurgen Klopp term for it that he used the other day. But the more messed up a situation is, the more the court should be very careful not to make broad pronouncements. Try to deal with the situation at hand, because if you try to write a broadly out of that, you can mess up everybody else. And I think that's one of the strengths of our system. We've messed it up at times, Gustavo, but generally we're pretty careful when we see a goof nut situation to try not to screw it up for the rest of the world.
And maybe just to go back to the beginning of my what I was saying, I think one of the weaknesses of the civil law when we are dealing with fiduciary duties is, my impression is that nowadays Delaware is especially you try to, this is a case about fiduciary duties. You're not trying to discuss, this is care, loyalty, in order to avoid this kind of pitfall that should be avoided. And here in the civil law, we don't have this flexibility, because it's either Article 153, it's care, it's loyalty, is the article in the between. So, but when you think about, we have care, we have loyalty, we have cases, but it's hard to
yeah. But I think
he needs to base his decision, his opinion in a specific article.
I know, but what I'm saying is, if you have the interpretive authority, look, our cases too, we do discuss the duty of care separately from the duty of loyalty. We get lost in these same complexities. And so I don't see, I think that you can, I think the question really that you all need to ask as a society is, if you have these general principles that are rooted in law, what interpretive flexibility are you going to give to whoever does it to realize that the idea of being being a fiduciary can't be segmented entirely, and that there's one of the principal things you think about if somebody engaged in no process at all, right? Made a big decision. There were no documents, no meetings. One of the first things you think of, Gustavo, is there something going on here that I don't see, right? Oftentimes, sloppy processes are indicators that there's a conflict of interest. So I think the question is, I said one of the things we've talked about students that I think would help you all as students is a lot of the situational learning you have under your law is in arbitration, right? But the idea of private decisions in arbitration is because arbitration was a choice of private parties. When arbitration is used to deal with public companies and is required by matter of law, I think one nifty thing, and maybe the three of us should write an article about this afterwards with Gustavo, is to make those arbitral decisions public. When you put together the CVM decisions and the arbitral decisions in public companies, think about what you'd be able to study, right? Have any of you been able to read an arbitration decision?
Some of them you don't even want to read.
Well, I've found, I'm not actually capable. I don't read. I actually am illiterate. And I found that's helpful, and as a judge, because it frees my mind up to approach things in a way that's unburdened by knowledge of the law. That's not true, dude. I may not be good at reading, but I try to do.
The question here is, on jurisprudence, how you build on jurisprudence. And I had the chance to be on an administrative appellate court for a while. And one of my concerns is not to change decisions or jurisprudence. And I would joke that it was like brain surgery. You only open and go in if you need to change, or it's vanity, but how do you build on what already exists, good decisions, and why you need to progress and make new decisions in order to progress the jurisprudence? And
I think it's a great.
and when to decide to go in and do the brain surgery or stay out, or how you build on that without breaking what already worked.
No, I think it's a great question and very difficult one. And students, in the US, there's different forms of precedent where some precedent is binding. Some precedential is what's called persuasive. For example, by me coming to think it would be useful to have your arbitration decisions be public, that doesn't mean you'd make them bind a future arbitrator, but you'd have the body of law. And on our Court of Chancery, if I, as a member of the Court of Chancery, issued an opinion as a trial judge, that wasn't binding on the other trial judges. When our Supreme Court, the court I sit on now, when they're the appellate court, if I issue a decision, it's binding on every member of the trial court. And the thing we struggle with is if you become more as an appellate court like a code writer, you mess up the system. So you issue a decision that's supposedly in one case, but the pronouncement of the court is so broad that it has the effect of almost being like a statute. Business people are trying to do things. The Court of Chancery may not agree with it, but they're bound by it. You face this precedent. How do you plan a transaction? You think this transaction is not really good. You're going to advise your client, though, to challenge it, right? What I mean is if you challenge it, you know you're in the face of a Supreme Court decision. It could be the entire marketplace thinks that decision is stupid. One of the things that happens in Delaware is if we put out a decision that a lot of people think are stupid, you know how long it takes to find that out? Yeah, the firm memos. Have you seen these firm memos that fly around? They haven't even read the decision. They send firm memos out. It's impossible. They must have had an artificial intelligence machine read the 50-page decision, the things that. So one of the things we try to be is open to criticism. I think that the appellate court needs to be very mindful of writing in a way that's not what I call for the ages, not like Moses on a tablet, be more provisional such that you're not putting the trial judges in too rigid a position. I think stability is important. You don't lightly deviate from it, but where you deviate has to be when you know you've made a wrong turn, where you're getting, look, if it's only one constituency that's upset, but if it's a broad range of practitioners who just said this doesn't work, I think the court has to be flexible enough to acknowledge that it's human. And we've been more willing during my tenure as Supreme Court, to be honest, to say, upon reflection, this might have been a better approach. Judges, like they use the highfalutin things, often like to perceive that they're infallible, right? No, they're not. But the problem is the worst kind of judge is the one who pretends that all of his rulings are divine, that the consistency you find in them is that all of his rulings are divine, right? And so I think it's a struggle. I don't think. No, but I think it's a struggle, and I don't think there's easy way. But I wouldn't reverse precedent in general unless you are convinced that there's a demonstrably better way, or that you've made a mistake. It shouldn't be what I call a jump ball, drop ball, right? It shouldn't be just a 50-50, because usually the 50-50 things, and then another thing appellate court should be, can often be a couple of reasonable ways to go about things. But when you've actually taken a wrong turn, where I say our court takes the wrong turn is when we actually confuse ourselves with code writers, where you get the situation at hand Our judges, I call it being a Coney Island hot dog who wants mustard squirted on you in public. What it means, you have people who want to celebrate themselves. There are judges who know they've got a big case and they try to write something that's a big deal. That's often when our courts have gotten in trouble. And that's when I think you have to look at when that doesn't work out so well, being willing to change direction. And I think we're pretty good about it, but I would say, to be fair, we could be better.
There's a student that wants to ask
Sure.
a question. Where?
That's good.
Sorry, I'm a little bit nervous.
Don't worry about it. I've been nervous. I've been nervous. I love coffee with ice in it, and figuring out how to order that in my like bare phrases of Portuguese and mescalpe has been difficult. So I can identify with you.
What I wanted to ask is, we know that US has a very good tradition and broad tradition in law and economics. So I wanted to know how the Delaware judges perceive the economic results of their decisions, and how do they base these decisions?
No, I mean, that is something we struggle with. One of the things I was saying, Professor Pedro Paulo has taught here for a long time. I was lucky enough, when I teach, I learn. We have to do something called appraisal. And in appraisal, one of the remedies you get in a transaction is if you think a merger is unfair in certain circumstances, you can seek appraisal. And the court will award you the fair value of your shares. So say that the merger was at $47. You say, I should have gotten $52. I went to law school. I was a political science major. I wasn't a corporate finance person. I have to appraise this. And I get an expert coming in from Harvard who says, for the petitioner, you're the petitioner, says it's $52. The people who were defending the deal is 47. They're saying it was really like 39, but we were just generous and we gave you 8 extra. They got discounted cash flow models and all this. Part of what I did is I taught a seminar at Penn with my friend Mike Wachter, who just finished 50 years. He was an economist at Wharton who then joined the law school factory. And I learned about corporate finance. I think judges do the best they can. I don't think we always do it great. Modesty, I think, is really important. Being careful of knowing what you know. In that case of an appraisal, you do the best you can. You make clear that you're dealing with the input you have. Try to consult the literature. One of the things about going to a great school like this is learn some of these things. I got to tell you, if you want to do disclosure, right, if you're going to write disclosures, you need to actually learn about some basic principles of corporate finance, because it's not really, if you're going to write about an investment banking a decision in a disclosure, if you don't actually understand a little bit about the cost of capital or all that kind of stuff. But it's a struggle. And I think where we try to strike the right role, and this is where I think the business judgment rule idea, this idea of impartial decision-making helps, is if the stockholders got to decide for themselves and there was full information and they were disinterested, this instinct of the judges not getting too deep into it, that kind of modesty about that helps you not make economic judgments that are wrong. But then we go in the other direction, which is if you're going to, where you risk making a wrong economic judgment is there's a conflict of interest transaction. There was no special committee. It's a clear conflict between the people who did it, who were on the inside, and most of the investors. Then we put the burden of proof on the insiders to prove it's fair. And we err in that situation. If there's any burden of uncertainty, like you're not sure whether it was fair or you're not sure the amount, you actually then resolve the uncertainty against the wrongdoer. So I think this tradition of when it's impartial, we stay out means we don't mess things up too much. This tradition of we look harshly at conflict transactions when you don't give the power to the minority investors to protect themselves means sometimes we make a lesson out of somebody who's really done wrong. But because of those things, we minimize the situations where we're making directly economic judgments. And that's probably the useful thing. It's a complex world, right? And the other thing about markets is they're not perfect by any means at pricing things. But if all the stockholders have gotten a chance on full information to price the transaction for themselves, you've got to be pretty arrogant to think as a judge that you know better about that. And so our law kind of discourages that. But again, when you don't have market information, right? Well, what I mean is if Chico and I do this conflict transaction, we didn't test the market. We don't know what anybody would bid. Whose fault is that? It's us. So then the burden is on us to come in and improve. And that's where, frankly, yeah, the courts might be a little imprecise, but probably in the right way. And you know what it results in? Say that we get a $1 billion judgment against us. Are you going to do it the same way we did the next time? No, you're probably going to get a special committee or do something like that. And so you can figure out ways. What I'm saying is the law, where it's harsh and where it gets into those things, provides enough lessons for people that you then plan things hopefully in a fairer way, where there's less reason for the court to actually get into the substantive economics. But yeah, it's one of the more uncomfortable things as a judge who's primarily law trained, right? I mean, it's difficult enough to learn the law, isn't it? Without also having to be an accountant or an economist. And so when I've had those cases where I've actually had to do that, you know, I do feel a little bit uncomfortable about it. And I'm not sure I've always gotten it right. And it's really hard when somebody from Harvard, they apply the same, they were supposedly applying the same method of evaluation that they're taught in schools. And here's the MIT professor who is $15 away per share from the Harvard professor. And the cost of capital, you know, what do you do with that, right? Because they've been paid by somebody to academics. One of the things we're actually struggling, and I know there was an excellent question. We struggle with this. Appraisal opinions, the expert reports are often, have traditionally not been made public. So a professor could come in and none of his colleagues in academia would necessarily see his opinion. One of the things we're actually doing right now is to shine a little light on that. We think if those professors, when they come into court, what they say has to be seen with the same scrutiny as they'd put out an article, you're going to see that $15 difference shrink a lot because they're getting paid a lot of money without the reputational cost. So we're actually going to use disclosure, I think, to address this problem.
Okay, so regarding conflict of interest transactions and majority of the minority rule, why don't you just prohibit altogether the vote of the controlling bloc? I just provoking that because of the school of thought here that you would make those.
Let's explain to you a little bit the question, okay? Yeah. In Brazil, there is a provision in the United States, of course, the majority needs to vote, and then you get the majority of the minority, right? In Brazil, there is a provision that says in a situation of conflict of interest, theoretically speaking, the majority cannot vote.
There is no such a provision, Julian.
Wait.
I'm sorry. There is no such a provision.
So that's the current interpretation of the provision.
Sorry, we're going to fight this. That's why I said we shouldn't explain this. Because you have conflict of interest for shareholder and for officers and directors.
Okay.
For shareholder is the material theory that is prevailing. For the directors, today, as the stance is the formal one. So you are prohibited from vote. So it's a big discussion. It's very bad. I just won a case at Conselhinho in which some of the one member that left invented some kind of theory that would be a new theory. And there's a vote that there is a new theory of Calixto Salomão about conflict of interest, which was the vote of the representative of the SEC in the board in my decision, which in my opinion is totally wrong.
Okay, so going back, as you see, this is a discussion, and it's a harsh discussion. We are here in an academic discussion. I fully agree with Chico's position on the subject, in the material position, but there is a discussion, right? There shouldn't be, but there is a discussion. So the discussion is the following. Some people say, if you have a conflict of interest as a shareholder, controlling shareholder, you cannot vote, and you have to let the majority of the minority to decide. So as the law does not say what a conflict of interest is, so for example, the law does not say it's self-dealing with conflict of interest, or, you know, it's not self-dealing, it's a little bit more than that if you have a partial interest and so forth. So the law is not clear. So a part of the scholars say, look, as there is no definition of what is a conflict of interest, you must first see if it's a conflict of interest. So if you see that the vote was given in the best interest of the company, then by itself it means there's no conflict of interest, because you look at it and it's in the best interest of the company. You have, of course, the burden to show it's in the best interest of the company, and then it's okay. So it's like almost saying, in a very broad comparison, it's almost like saying it becomes an entire fairness issue. Other people say, no, you just cannot vote. And why? One of the best defenders of this theory was here with us, Chico, Marcos Pinto, and he gave and I asked him, like, I made him like 10 questions, like, how do you know if the guy can vote or not vote? How do you decide? You know, you're not an equity guy, so how can you decide if it is a conflict of interest? And after asking this like 5 times, he finally, and this is a guy I respect and like, he finally said, look, Julian, it's like that, I don't remember the name of the Supreme Court judge that said, yeah, it's like pornography, you know it when you see it. So, yeah, that was the final answer he gave me, and I decided to rest the case. Okay, I'm not.
That's
going
our
to discuss this
our current U.S. Supreme Court is pornography. Guys, and you can see it. Here's where the answer. Citizens United. The question, it goes back to what I explained to the students about the structure of our law. You have the authority to do something with the approval of the board. You have the legal authority to do it with the approval of the board. We originally had situations where we said, and I want to get to this point about defining a conflict, but a self-dealing, you're on the other side of the transaction. You couldn't do it without unanimous approval, or you couldn't do it at all. We went away from that. You can do it as long as it's on fair terms to the corporation, and the burden of persuasion is on you to prove that. If you're willing to undertake that, willing to undertake that burden of persuasion, you can do it. What if you think you need to act right away? To be honest, like, stuff happens. Like, there are construction companies, they need a bunch of steel. Maybe you have somebody on the board who has a steel company. You need like a lot of steel because something went wrong with your original supplier. You need it by next week. So our law takes the thing is, you can do it. You then, it's not necessarily a breach of fiduciary duty, but you start with the burden is on you to prove it's fair. In terms of this vote situation, the effect of the majority of the minority is, of course, to sterilize the vote. But it's really important to look at this because there are voting dynamics too. Remember, in our thing, that there's sometimes, it's not a majority of who votes that's enough necessarily to do certain transactions. That's another issue. For a merger, for example, in the United States, you have to have a majority of the outstanding stock. Stock keeps trading. So you could have a situation where a majority of those who vote approve a transaction or at a meeting, a certificate change, but they're not a majority of the outstanding. So that's another technical issue, is that for the quorum requirement or the vote requirement, you may need the majority. But if you give the majority to the minority, you say that change to the charter will only go forward if a majority of the minority agrees. Same thing for their merger. It has the effect of essentially making your vote not the deciding factor. And so I think we think that flexibility, that's the right balance. It has the same effect. If we were to say you can't vote on that transaction, you can imagine a situation where a majority of the minority who actually votes approves it. But it's not sufficient number of votes to actually take the effective corporate action. And so that's the balance we strike. And you don't have to do any of these things. That's what we're saying, is you can just nakedly pursue your self-interest and then go into court if you get sued and say, okay, I used my own votes. My affiliates on the board approved this. Here's why it's fair. Here are my experts. Here's the evidence. Here's the market pricing. And yeah, we didn't use these procedures, but it's fair. And if you convince the judge, then you win. Now, it's difficult. Most people say, I'm not going to do that. That's kind of crazy because the two Harvard professors, MIT, they're going to come in against you. But sometimes it happens. And so I think in general, what our law does is flexibly, it's very rare that that naked exercise in self-interest happens. Much more common that there's going to be a procedure like a special committee or that majority of the minority. And so, so I think it works to protect fairness, but it doesn't have the rigidity of what you're talking about.
And when do you say, can you tell me, without using the example our good friend Marcos gave us, what constitutes a conflict of interest in your view or in Delaware view? How far does it go? For example, you know, the wife of my, the ex-wife of my brother, with whom I don't have a lot of relationship, is in the board. So is this a conflict of interest?
Well, I mean, I had a case where somebody's brother-in-law was on the board, and somebody argued, a good friend of mine from Skadden, a really great lawyer, argued, well, not everybody likes their brother-in-law. And I said, well, if you're the controlling stockholder and you don't like your brother-in-law, why the heck has he been on your board for 10 years? So, I mean, some of this, but I do think it's an important thing.
Of your wife.
Right, but that's the thing. Here's why I asked whether direct.
Let's do it the other way
No,
around.
but what, I mean, I want to get to the principle of what you're trying to get at, because I think it's important. And I think it baits for the students. It's this question of the code and then interpretation. I think it's virtually impossible to write down every possible conflict of interest that might arise. And if you try to do that, you're either going to be over-inclusive or under-inclusive. It's really easy to say self-dealing, like a member of the board owns another company or has a thing and sells something directly to the company. But imagine, let's take a merger and acquisition situation where the company is selling to someone else. Julian's the controlling stockholder. He has a 47% interest. For his shares, he's actually getting, everybody's getting 225 real per share. He's actually taking that. but he's the founder. They wish him to remain on the board. And in order to do that, they're giving him a consultancy contract. Imagine the consultancy contract is essentially equivalent to Neymar's annual salary from PSG, right? Actually, it's not a bad salary. I mean, you might have been as effective in that French final as Neymar. You could probably punch better, but but I mean, imagine it's that level of a salary, right? And Julian says, well, I took the same amount per share. Well, the court would probably say, well, wait a minute. That's consulting agreement is really material in the context of the transaction. It turns out to be another 50 real per share or something like that. And you weren't getting the same thing when you sold the company as the minority. It's really a conflict of interest. Well, imagine on the difference. And the reality is that Julian really is the founder. He really has been important. And when they buy the company, part of the reason they're willing to give you as minority investors and everybody 225 real per share is because of the talent that he has. And he's agreed to stay on the board, even though he would not really like to do it. But he's agreed to do it for 3 years. The salary is much more modest in comparison to what he's getting for his stock. It's a small thing. Our courts would probably say in the latter situation that there's not a conflict of interest, that there should be we'll talk a little bit tomorrow about no more heightened scrutiny. It's really business judgment rule. And that, to be honest, because he was willing to do this, it probably helped everybody else. But in the first situation where he got the PSG Neymar salary, we would probably say, no. That is a conflict. And where I'm saying about this, Julian, is I don't know how you write those down in advance. And I think what you have to have is a balance between the code addressing and recognizing there are situations of conflict of interest, but then giving some adjudicator, whether it's a CVM, whether it's an arbitrator, whether it's a court, the ability to situationally determine the situation. And it's not that the principles vary so much as the facts vary, right? That's it. That's the same thing. There's a consulting agreement and a service on the board, but the materiality in the context of the overall situation varies. And that's why you need some case-by-case look at this situation. So
Let me give you another.
Very tough to know when it turns to be part of the price and when it's real remuneration for staying the board.
But by the way, when you see everybody in the same family or in the same circle on things, we have a so-called pleading stage at the initial stage of a case before there's information for the plaintiff. You don't tend to assume. We've been trying to be more human about this. If the brother-in-law and sister-in-law are finding themselves in the same thing, I mean, Brazil's a place where you have very friendly family relations. I went to a family party here with some folks, and everybody's ex was there, and everybody was partying together. It does because they were exes. They have children in common. They can still be very close, right? All of my exes live in Texas. No, that's actually a song. But
Leo, let me give you a more Brazilian example, okay? Let's say the controlling shareholder, it's something that needs to be done. And, it's not such a big company. And in Brazil, we tend to throw things at the shareholders meeting that you would never in the US, okay? Right. So it's actually a business decision that needs to be approved by the shareholders meeting. Let's say it's something relevant for the company, so it needs to go to the shareholders meeting. And then the shareholder wants to vote, and then it's not that the brother-in-law or the sister-in-law is in the board. The sister-in-law is actually the person who's selling something for the company. So the sister-in-law has to sell this to the company, and the controlling shareholder says, "Look, there is no alternative. Let's approve this. This is the best alternative." Would you interfere on that?
Probably not. But I mean, again, the former sister-in-law, interfere, again, the question would be, You go ahead with the transaction. If someone sues, if it turns out that the reality is she's the former sister-in-law, I mean, you know, reality in life of families is anybody have someone who's an in-law that you actually like better than the person who's your blood relations? Right? That's never happened. Like where like your uncle is not really blood related to you, but he's a cooler guy than your aunt or vice versa.
It happens, but it doesn't mean you have a conflict.
It doesn't,
Per
but
se.
it does not. But here's what I'm saying about facts. You do not know. Like one of the things I ask about directors, we have some cases that talk about mere friendships. I mean, do you have people your friends you go up to? I just want to let you know you're a mere friend. You're a real friend. But you know when people have, I will tell you one of my signals about friendships, that is when two people have intermingled their family with vacations.
No, that's a friend.
That
At the beginning of the vacation. At the end, it may be the-
yeah, but that's what I'm saying. Imagine a family. We have a family where every summer for 2 weeks for 10 years, they get a beach house together for 2 weeks. Because it's also different. The spouses are friends. The children are friends. The implications of breaking the relationship are huge. And what we're saying about is trying to define up front what's a conflict of interest. We've had these trouble with independent directors defining who they are. You have to have some tests, but you need to have a residual thing for what makes life worth living is the relationships you have with other people, right? And the other thing is relationships evolve over time. One of my things about independent directors is how long can you be an independent director? Like if Chico is the CEO and Professor Pedro Paulo and Julian and I have been independent directors on the board for 7 years with Chico. And that's my point is it changes. It doesn't mean we can't be good directors, but the idea is it would be very weird if our relationship was same with Chico after 7 years as it was at the beginning, right? And so what we tend to do, Julian, is look at hopefully in as realistic and fair a way as we can at the objective circumstances, look at how important the relationship or the factor is in the context of what's going on, and then make a judgment about how intrusive the review would be. And I don't think that can be done in a code in advance. I think you have to give regulators, arbitrators, and courts some reasonable discretion about it.
Okay, so tomorrow we will go on with this discussion. It's not over. I think we should pass for Professor Pedro Paulo to finalize today, and we go back tomorrow.
Before we do that, I would like to ask a big applause for you.
Certainly.
Well, see everybody here tomorrow.
Thank you, guys.
Hey Leo, how are you? I like the Flamengo match. Yes,
It was, well, I was glad that they scraped through. It was fun to go there. Did anybody teach you how to shoot? No, it was I mean, it was
Eu não sei nem como é que você ia votar. Eu acho que você ia votar a meu favor. Eu achei que o interesse. Não tinha demônio, não tinha demônio. Ele estava querendo arrumar um jeito de me adiar e me fuder, é só isso. Oi.
Tira uma também, Chico. Chico, vem tirar outra aqui, Chico.
Leo, she's going to Harvard.
Yeah. You want to Harvard this fall?
Ah, te deu o carta da segunda edição. Aí você autografia dele, sabe? Obrigado, hein, meninas? Muito legal vocês terem.
Exatamente.